Hello everyone, welcome to Management 413 Employment Law here at the UAB Ch School of Business. In this video we will be covering affirmative action using Chapter 8 of our textbook. Here are the topics we will be covering. Please stop, pause, make sure you look at these. Affirmative action is widely misunderstood. Look at this definition. Affirmative action can be a collection of actions appropriate to overcome the effects of past or present practices, policies, or other barriers to equal employment opportunity. If affirmative action is legal, and it is not always legal, it has to be taken pursuant to a plan. When people are surveyed about affirmative action in the United States, there are mixed results. The more you tie it to the general desire for underrepresented minorities to get a better shot in the workplace, the more likely people are to say that they support it. On the other hand, the more that you tie it to race, the less likely people are to say that they support it. Sometimes affirmative action is actually required. For example, if you have a contract to sell goods or services to the federal government, we'll talk about that in a minute, or if you are settling a discrimination suit, it may be that you have to undertake an affirmative action plan. There is no general requirement that all employers must have an affirmative action plan. If you have one, you have to make sure that it is legal, because think about this. Any plan that takes into account an applicant's or a employee's protected class characteristics is disparate treatment, which we know from our prior classes is illegal under Title VII to the Civil Rights Act of 1964. So if you have a contract with the federal government, you are subject to Executive Order 11246 that's been around for over 50 years. Any contract for more than $10,000 requires that you do two things that we'll see in the next slide or two. It also requires that your subcontractors do those same things. Look at the case at page 265 of the textbook, where that was a surprise to a hospital in Pittsburgh that had no direct contract with the government, but it was a subcontractor to someone who did. Here's the actual wording of Executive Order 11246. An executive order, by the way, is a rule set forth by the President of the United States, and it is not a law passed by Congress. This executive order is monitored by a branch of the federal government called the OFCCP, the Office of Federal Contract Compliance Programs. They will periodically do inspections of contractors and subcontractors, and they will inspect all facilities of a contract firm, not just the one that might happen to be doing work for the government. They collect a great deal of information from contractors as well. Sometimes affirmative action is required as a remedy for something that went wrong in the past. For example, if an employer has been accused in court of illegal discrimination, adopting some sort of affirmative action plan might be the way to settle that. As I said, affirmative action might be considered reverse discrimination if it requires an employer to make employment decisions based on protected class characteristics, such as whether or not someone is a male or a female or Caucasian or African American. There are ways to encourage a more diverse workforce by widely advertising positions, for example, but taking it to the point where you are giving preference to women and minorities could be a problem legally, because that would be disparate treatment. Here is a simulation for a pair of you. of a case in which someone argued that there had been disparate treatment, sometimes called reverse discrimination. This is a fire department that gave preference to women because the percentage of females in the labor market was higher than that for female firefighters. It is almost never going to be permissible for an affirmative action plan to establish quotas or to reserve opportunities solely for people in a desired class. Instead, the goal should be to take protected class characteristics into account for the purpose of undoing past discrimination. It can be one of several factors. How is an affirmative action plan judged under Title VII of the Civil Rights Act of 1964, which, as you know, says it is illegal to make employment decisions based on protected class characteristics? In order for a plan to be legal under Title VII, it has to be remedial. The court has to find that there was or is a manifest imbalance between the protected class composition in the employer or at the employer and as opposed to the labor market generally, and the plan has to be temporary in nature. Here is a U.S. Supreme Court case looking at the legality of an affirmative action plan at a transportation agency in California. The plan was upheld because the gender of qualified applicants was just one factor that was taken into account. When we are looking at public organizations, government organizations, the scrutiny is even more intense because the Equal Protection Clause of the United States Constitution would apply. And in that case, the learning of the U.S. Supreme Court is that you can only overcome an equal protection argument, that is, that the action of the government entity in its affirmative action plan does not provide equal protection for, say, men and women. You can only overcome that type of an argument if the plan survives what's called a strict scrutiny by the courts. You have to show that the plan serves a compelling governmental interest. That is extremely high standard to meet. That is the standard that universities have to use when they when they have affirmative action plans for admissions, for example. University of Michigan about 10 years ago did exactly that. They had various plans for increasing the percentage of African Americans in their various schools at the University of Michigan. The Supreme Court of the United States upheld some of those and struck some of them down, but very significantly, the voters in Michigan then amended their constitution to say that it is illegal in Michigan for the universities to use race or gender-based preferences in admissions. Here are two cases involving public entities, cities with affirmative action plans. You can see that in both of these cases, the plans were struck down. If there is a plan, there should be three main components. You have to analyze your workforce. You have to conclude that your action that you're taking, for example, making race or maybe gender a factor among several, is reasonable, and you have to have actually taken action. Look at the graphic here showing the required contents for an affirmative action plan under Executive Order 11246. You have to identify your problem areas. That would be part of the self-analysis, and look how the word glass ceiling is used there. A glass ceiling can be an indication that there is a problem. The EEOC does not have a specific requirement for what an affirmative action plan has to look like exactly, but they do expect you to describe your organization and to describe your job groups. In a workforce analysis, they will ask you to describe all of your titles and exactly who does what, and look at where there are problem areas in hiring whatever protected class there might be. The definition of underutilization can be important. The Supreme Court says that affirmative action plans should be used when there is a problem, and their definition of a problem is a manifest imbalance. This is not the same thing as the 4/5 test. They don't require any mathematical formula. They simply say that in order for an affirmative action plan to be necessary, and to be, in effect, disparate treatment, there has to be an imbalance between what is available in the workforce and what your organization has. Here are some actions that would be reasonable for you to take under a plan. Have goals, timetables. Here are some very specific things you might see in an affirmative action plan to try to increase the percentage of people in a protected class. Maybe get people earlier in their careers, such as in internships. Offer assistance to candidates in taking tests that seem to screen out the protected class you're trying to promote. If you're trying to recruit more people of other national origins who perhaps don't speak English, arrange for English language or literacy courses. And then finally, another example would be to facilitate support groups for women and people of color at your organization to make sure that they can be successful over the long term. What have been the results of affirmative action? Here you can see that in recruiting, when comparing companies with affirmative action plans and without such plans, recruiting is about the same. In hiring, those who had plans had somewhat lower educational credentials in their employees. Very importantly, job performance levels were equal to or exceeded job performance levels among those who were hired under affirmative action plans. Another goal of affirmative action is to increase diversity in the workplace, not to try to overcome some problem, but simply to recognize that a workplace is going to be a better workplace, help understand customers better if it is diverse. That is very much what underlies admissions programs such as Michigan and the University of Texas. The U.S. Supreme Court recently upheld the University of Texas at Austin's affirmative action plan that some people said was reverse discrimination. That's it for this set of slides. In our next set of slides, we're going to be looking at the very important topic of harassment.